Finding Effective Counsel from Jail, Models of Legal Representation in Texas. Let me begin by saying it's funny to have somebody from Washington sitting here to moderate a panel on representation in Texas, but I will say that I've had the privilege for several years of volunteering during the summer at Crowbar in Harlingen, Texas, and I've also had the opportunity in conjunction with some of my work through the ADA to visit, interview, and represent people who have been detained in Pearsall, in Willacy, when it was open, and other facilities around Texas. So although Texas is not my home base, I've had a little bit of an eye on what detention is like here, and particularly about the obstacles to access to counsel for people who are here in Texas. So I want to spend just a minute setting the stage. I think most of the people who are here know, but I'll repeat for benefit of those that may watch it later online, that the threshold issue, the threshold obstacle for access to counsel is, of course, the statute itself. And that Section 240B4A of the Immigration and Nationality Act provides that respondents in removal proceedings have the privilege of being represented by counsel as long as it is at no expense to the government. So we take the statute as we find it as the starting point and recognize that under the current regime, most of the representation of immigrants, including detained immigrants, has to be by legal service providers or by pro bono lawyers. The provision as not only applies to detainees, but also applies to vulnerable populations. That includes children and mentally ill or otherwise mentally disabled individuals. So I want to set the stage for folks by realizing there are no lawyers unless the people can afford to hire them or they can find one not at government expense. Now, aside from the statute, could anything make it harder for detainees to find representation? Well, you could, I guess, locate detention centers in remote rural areas far away from urban centers where lawyers are concentrated. And then you could introduce an economic downturn that makes legal service providers confront the same limitations in funding and staff cuts that the government itself has been experiencing in this economic climate. And then you could have large law firms downsizing with increased pressure for billable hours on their associates so that the time and flexibility available to them for the pro bono work that they'd like to do is made even more difficult. So that's, I think, the perfect storm in which we come to the question of representation for detainees in Texas right now. I wanted to mention that in your materials there is an excellent fact sheet on immigration detention in Texas, and it has a lot of facts and figures for you, but I want to highlight just a couple of them. One, detained immigrants held by ICE in facilities in Texas, 7,985 daily, which is 24% of the total population detained by ICE daily. 3,000 of those on a daily basis in ICE, held by ICE in Texas county jails, and 3,200 in remote Texas facilities. And remote is defined as more than 60 miles away from a metropolitan area and is not always, but most frequently, the IGSAs, the state and local county jails that we've been discussing. Another important thing, and I haven't been here all day, so I don't know if the legal orientation presentations that are government funded have been discussed much earlier today. The highly regarded L.L.Ps reach only 15% of detained immigrants and only 35 of those in removal proceedings annually. So where the L.L.P programs are a tremendous help and a huge benefit to those who are lucky enough to receive them, there are a large population of people who aren't even getting that limited access to information and source of pro se materials. So that's the background. The good news is that we have 3 outstanding panelists here to discuss the issues and then to engage in a discussion with you about them. And we're going to hear from them about some of the strategies that they've developed, some of the challenges they faced, what are some of the innovative models that they've developed, both for legal services and pro bono delivery. And in particular, we're going to talk a bit about where the public defenders and the defense bar fit into the picture for those detainees that have criminal convictions. So all of the speakers have a short presentation individually, then we have time for discussion among the panel, and we have a bit devoted to suggestions for solutions, recommendations for improvement in the system, and we have a generous amount of time set aside for your questions and comments. So I really do want to encourage people to stay and let us make your questions and comments part of the dialogue. So first, to my immediate left is Denise Gilman. Denise is a clinical law professor and the co-director of the immigration clinic here at the UT School of Law in whatever city we're in, Austin. So much for my Texas cred. Tonight I'm going to Dallas, so I'm confused about where I am in Texas. To Denise's left, Jonathan Ryan. Jonathan is the executive director of RAICES in San Antonio. RAICES, for those who are not familiar with the organization, is the Refugee and Immigrant Center for Education and Legal Services. And Jonathan is going to follow Denise in his presentation. And last but not least, we're thrilled to have with us David Gonzalez. David is the founding partner at Sumpter and Gonzalez, which is a criminal defense firm here in Austin, serving both private and indigent immigrant clients. So first, I'm going to turn right to Denise to talk to us about what they have done here in her clinic, what she's seen, what she's observed.
I do want to thank Human Rights First and the LBJ School, for that matter, for putting together this important event. It seems just the right approach to me to combine the experiences from the criminal justice system and the immigration detention system, and to do that in a manner that allows for dialogue and for sharing. And I particularly think it's fantastic that they've chosen to take this on the road and to help us think about it in different areas around the country. It really does feel like Texas is sort of ground zero for detention a lot of times, but I know these same issues are coming up in many other areas of the country as well. It just is very intense here. It really is, and important to think about it. I also especially want to thank those of you who remain in the audience for sticking it out through the end of this long day, and appreciate that, and hope that this will still be a dialogue and that we can have some back and forth. But my relatively straightforward task today is just to describe the model that our immigration clinic has adopted for providing pro bono representation to detained immigrant clients in our area, as a way of looking at a model that has some real benefits, I believe, but that also has some serious limitations that might help inform the discussions about what needs to be done to allow for better and more expansive pro bono representation of immigrant detainees. I want to mention that one of our recent graduates from the clinic, Amelia Louise-Fisher, is here, and she largely ran the sort of HUDO work that we did, the HUDO detention facility work that we did last year, so you can also ask her questions if you want to know more specifics about the way we do it. But so what do we do specifically, and what centers do we work in? So we do not generally do much work at the Pearsall Detention Facility, which is located about an hour south of San Antonio, Texas. That was described at the very beginning of the discussion this morning, because that's a good 2.5-hour drive for us. And we also don't really do work at the new Carnes Civil Detention Facility, because I just had to drive by there this weekend to take my kids to a soccer game in Corpus Christi. It really is a full 2 hours from here. So that's a reality of how long it takes. We did a full individual case through the merits at Pearsall last semester, and actually there's another student attorney alum here in the hall today, Nakia, who did that representation, and it literally broke our budget. I mean, literally we exceeded the immigration clinic's budget for the year and had to ask for additional funding from the law school to cover our work. And so that's why, as a realistic matter, we cannot take on individual cases at those farther facilities. So we focus most of our work at the HUDO detention facility, which has also been described is all women at this point in time, and is only 45 minutes away. So it's still a drive, but at least it's within the realm of something that we can do. But there are limitations on what we can do at HUDO as well. We do some bonds and parole, trying to help women achieve release from HUDO, and some occasionally merits hearings. But there are a couple of reasons why we don't do very much of that, even though the facility is really pretty nearby. First, with bonds, it's sort of a double-edged sword. If we are able to achieve release for the women, which is difficult for all the reasons we've talked about, they, of course, mostly don't want to be in Texas. And so they're detained for maybe 6 weeks during their removal proceedings until we finally get them out, or longer, and then they go to reunite with their families in some other part of the country. They never intended to be in Texas. They are just detained here because we have so many beds here, largely. And so they leave, and so their representation is interrupted. It would be much better, of course, if they were released right away, so that they could immediately go to their families before they've sort of started their case and started their bonds with one set of attorneys here, and then moved and have to find another set of attorneys in another part of the country. So we don't do very many cases of bonds for that reason. But on the flip side of it, there's a sort of procedural problem that makes it difficult for us. If the women are not released, there is no such thing as limited representation, at least by regulation, and so we're on the hook for the merits proceedings in immigration court all the way through the case. And that's problematic, and is why we don't normally do merits proceedings for detained cases, even at HUDO. And that's problematic because those proceedings move very quickly, and it is extremely difficult for students, for almost anybody, but particularly for students in an academic semester, to make the repeated trips to the detention facility and do what is needed to adequately represent somebody at a merits final hearing in their immigration case. It's also extremely difficult, as you can imagine, to provide adequate representation in terms of finding, the documents that you need from the home country, making phone calls, and all the rest when our clients are detained. So given the constrained time period, the academic schedule, and the way detention affects representation, we just can't, for the most part, handle those final merits proceedings either. A final reason, of course, that I have to mention as to why we don't do more representation of women at HUDO for release is that many cannot be released under the current interpretations and statutes, but a little bit of both. There is some room there for it to be a different model, but the way it's currently being run, we cannot achieve release under the current policy guidance, and so that is not something that we take on the representation for. So with all those limitations, what we sort of developed is that we try to provide sort of individualized assistance, pro se assistance mostly, to the women detained at HUDO. And sort of how this works is that American Gateways, and again, who spoke this morning, being the legal director, does the L.L.Ps that Karen mentioned. We do not do those, the legal orientation programs to the large groups of detainees at HUDO. And they, for the most part, because there are 500 women usually detained at HUDO, cannot provide much in the way of individualized consultation. They can just provide general information, answer some basic questions, and in some cases, provide follow-up. So we send students out once a week, a couple of students, to meet usually with 3, 4, 5 women who have been identified either through the legal orientation program or through calls that have been made directly to us by women who are detained. And we send students out kind of on a rotating basis to work with the women, to help them, everything with providing basic legal information and advice about where they are in the process, what's happening to them. Many, as has been mentioned previously, don't understand where they are, or why they don't know they're in Taylor, Texas, and much less than than Austin, Texas, because they never intended to be here. Provide basic legal information. We also help them when there is possibility for bond or parole to help fill out those documents if we're not actually taking on the representation. Just help them fill the documents. Sometimes we come back and we call their family members to help family members find out what they can send to help try to achieve release for their family member. We also do a lot of helping asylum applicants, which is a significant percentage of the population at HUDO, just filling out the basic forms for asylum, which are in English, of course. They're not allowed to be submitted in any other language, and so there often is a great need for assistance just in filling out the basic form and writing up a basic statement about what the case is about. And then we do sometimes help the women obtain basic country conditions materials, human rights reports that they can also provide to the court. So that's kind of the type of pro se assistance that we provide. And I think it's, you know, it's a helpful, it's a help to the women we see. But keep in mind that we probably only see less than 50 women over a semester out of the 500 who are there at any given moment. The women repeatedly tell us what a service it is. They're extremely grateful, so I think it's worth doing, but I definitely don't want to overstate the impact that we can have given the limited nature of the model. And, you know, there are other problems with it as well. You know, for example, right now, a significant percentage of the women detained at HUDO are waiting for an initial screening interview. They're in what's called reinstatement or removal. They're waiting for an initial screening interview, often 6-7 months before they even know whether they're going to be able to pursue a claim for refugee protection in the immigration courts and go forward on their case. They're detained during that period, and they have, you know, no right to any more legal assistance than what Karen has already described. And so what happens is we go to see them once and we sort of explain that to them, and we say there's not much more we can do right now because there really isn't. But then of course they call again and again, and we feel some compulsion to sort of try to follow up with them, but of course then that makes it difficult for us to see other women. So there are things about the way the detention system is working right now that make it difficult for us to even see you know, as many detainees as we could. And of course, limitations on resources are constant, even with a closer by facility. This semester, I've just described this whole model. This semester, we're not doing it because we can't, because we're working on clinics for the students who are applying for the new Deferred Action Program that Obama announced, and that's taking up sort of all of our student time and our clinic time, and we just aren't able to do the other. So those resource constraints are very real. The last thing I just wanted to mention before passing it along is that we do also, as sort of another kind of piece of what clinics or law schools might be able to contribute, is that we do actually sort of export our students occasionally to other areas of the state where there are even fewer legal services. Every January, students go to either to Provar in the Valley or out to El Paso to assist individuals in removal proceedings, in detention, and right after they've been released in those areas as well, because the need is even greater in those more remote areas. So that is one other possibility, but again, a week is a very limited amount of time for students to be able to provide meaningful service, although I think it definitely helps. And that's sort of the framework.
The impact of your budget of the drive to Pearsall when you were attempting to do that is 2 hours away, you said?
About 2.5 for us.
And the going to Pearsall literally broke your budget. Is it gas money or what?
Right. I mean, the school has to reimburse us for mileage because it's part of our work. Of course, there are sort of opportunity costs to put it in law and economics terms as well. You know, those 5 hours for an hour visit with a detainee are 5 hours that our students can't be working on other cases, that to the extent that supervising attorneys need to go. We didn't go on all of the trips, but we definitely went on some, you know, that we could be supervising other cases as well.
And you mentioned that the limited appearances are generally not favored or generally not allowed by the court here. Is there anything like, at least what I've observed in other parts of the country, is that some courts have developed an attorney of the day program or something that lets somebody stand in basically as a friend of the court without actually entering an appearance at a master or possibly for a bond proceeding. Do you know anything about any program like that happening here?
We absolutely do not have a program like that. And to be clear on the limited representation, the procedures manual for the court doesn't, the procedures, the practice manual doesn't provide for that and specifically precludes it, actually, at least on its face. Some of our judges are actually willing to be flexible on that. If we sort of talk to them ahead of time about doing limited representations to encourage the possibility of greater pro bono representation at the bond stage with the incentive that you won't necessarily be stuck in the case. But it's definitely not sort of a policy, and no, we do not have any procedures such as the way that you suggested. And I love to explore that idea, and we can raise it with the court at our next pro bono meeting with them. But I'm not sure that it will work, that they'll accept it.
And then the one other question I had is, does your clinic do very much work with pro bono representation? Do you partner with or refer to pro bonos at all?
No, we really don't, because we're at a law school immigration clinic. American Gateways, of course, does, and now that Casa Marianella, as was described earlier, has a legal staff as well, very small legal staff. Both of those organizations, as well as some of the organizations in San Antonio, do work more with pro bonos. But again, it's extremely difficult for any attorney to work with cases in detention, and I think it's even harder for pro bono attorneys who have other firm obligations.
Sure. So it's pretty much your clinical faculty and your students in a self-contained program. Right? Okay, thank you. So, Jonathan, can you tell us about the way it works at RAICES, how your programs operate, what you're facing, and how it may be the same or different from that Denise has described?
Sure, definitely. Thanks. And I'd also just like to say thanks for having invited me. It's really great to have the opportunity to come here and talk to everybody. Yeah, I can comment, and it's great to start with the clinic because that's where I started. I was a student at UT Law Clinic as well, and that really ignited my interest and my commitment to this work. And so I'm going to be a little bit biographic maybe as I kind of progress through some of the experiences I've had and then get to where we are today and some of the models that we implemented. But I just think in this access to counsel discussion, just the terms quality and quantity seem to just return to my mind in terms of the battle of access to counsel and trying to maintain that. When I first did my very first immigration case, it was here at the UT Clinic, and I also want to compliment the UT Clinic because I don't know, maybe we're spoiled here in Texas in terms of some things that we do have, and the UT Clinic, the St. Mary's Clinic, the law school clinics are impacting here. We couldn't do what we do without them. So many people would go unrepresented and unhelped without them. We have to heap praise on them because they deserve it, and we need to keep them in the fight. But it is a statement, as a general state of access to counsel, that these institutions are players, are real players in terms of the courts and in terms of the access to counsel, as much as private attorneys, as much as not-for-profits. And their mission is educational. I mean, they are there to teach students. Their mission is not, unless I'm wrong, I don't know.
It's double.
Yeah, that's an important part. They're there to teach the students and then to them. So, I recall my cases when I was a student. I used to wonder how would I ever do this as a private practitioner or out in the world, because we would prepare those cases. It's I guess almost a kind of a satire now. The law school clinic cases that just are proven to the hilt. You got to bring some wheels to bring the case to serve the documents. And so that was my formation, and it's very satisfying. You get to dig into the case. You get to really develop a profound relationship with your client and learn a lot. And you help one person, and that's very important. I transitioned from the clinic to American Gateways. That had a different name. It was PAPA at that time. But I started off as a staff attorney at American Gateways. I'll refer to it as American Gateways. And my task there was to work on detained representation at the Pearsall Detention Center. This was before we had the L.L.P program, which did come to us in November of 2006, I believe. Prior to that, we would travel out to Pearsall. We had cases. We would make requests to the OIC at the time, the officer in charge, to visit. We would do that maybe once a month or once every other month. And it was a real jack in the box in terms of what you would get. I remember one memorable visit that we had, and you talk about access to counsel. So many people try to get to the detainees, but we got some detainees this one day. We showed up, and I think it was a holiday, or maybe the senior man didn't tell the second in command that we were coming, and so we showed up and we said, well, we want to see some detainees. We'd like to see them. And he just had this look in his eyes about, oh, you want to see some detainees, do you? Okay, well, I'll get you some detainees. So they marched us into the multi-purpose room, right? It was a large kind of racquetball court, very echoey room, and proceeded to march in about 200 or 300 detainees, men, women. This was before, this was when Pearsall was co-ed, men, women, people wearing blue, people wearing orange, people wearing reds, all your different kind of security levels there, and all different languages, all different cultures. I have a kind of an image of just a sea of people looking at us. And it was literally like showing up at a UN refugee camp with like a single pallet of water from from Walgreens. I mean, you do very quickly enter into a kind of an almost conflictual setup with the people as you try to triage, as you try to work through it and reduce the crowd into a sequence of individuals who you can discuss and try to orient, try to help. That was us kind of doing it by ourselves. The L.L.P. really did provide a vessel, a vehicle, and a method to, I think, approach these, and it gets you in the door, I think, in a way that you just don't. It's unlike any other experience I've had, let's say, with detention work. When we embarked upon the L.L.P., the access was increased, it was good, we became more routine visitors to the court, and we got to see people more regularly, we were there more often, but it really ups the ante in terms of what is the impact that you are going to make on this detention center. I kind of sometimes make the joke that you feel like you're running a dinghy boat around the Titanic. I mean, you're talking about a building in which there are as many as 1,800 people, and you're a team of 2 or 3 who can go out there and do your best. But the question really does beg the question is, if I'm as an attorney or as an employer, if I'm going to keep my attorneys engaged and interested, you cannot present them with an impossible situation. You have to provide something that can be done. So we did I think develop some strategies in that time that I think were really beneficial. We did focused on pro se assistance. We really tried to help people get their forms, their applications filled and filed, both for relief and custody. Another attorney, Eric Tiarina, who I don't know if he was here for a meeting yesterday, I don't know if he spoke, really developed a wonderful bond packet and a kind of a self-help bond worksheet that a person could fill out and apply for bond, him or herself. And that was great. It helped move cases, so to speak, to kind of use the court's jargon. But you got to balance that as well, quantity versus quality. Again, if you're helping someone to fill out a pro se 589, the asylum application, have you looked at that? They've already had 2 sworn statements at least at that point. And then they're going to have to testify, and they're going to have to provide documents that will corroborate it. So you really have to ask yourself the question. It might feel good to go to a detention center today and help someone write just an articulate, it was a dark and stormy night all the way to the end asylum application. But if that conflicted with the statements that the government had in their file, or if the person's unable to, toe that line on the day of court and in a way live up to my English degree in terms of writing that application, well, then they're going to get dinged on credibility. They're going to get dinged on corroboration. If they're unable to, if we're eliciting wonderful facts from these people that we're putting in their applications, and then they're unable to come up with a simple letter from brother or dad in home country, well, this can actually end up harming them. So, the pro se assist model, you have to really, I think, approach it with caution. I know my minutes are winding down, so I wanted to address pro bono as well. Along with the L.L.P. does come a mandate for pro bono, that you must engage in pro bono outreach and training and mentoring. And pro bono it's critical, it is important. But it is also a mixed bag. I think the way I would best describe it is as an investment. And I think people, when you're looking at pro bono to be a force expander, that it's just all of a sudden more lawyers and it's, we're going to have more hands. That's not the way it's going to be, and don't expect it to be that way. It's going to be frustrating, but it is an investment that can provide serious benefits to an agency or a program. You are going to spend more time with your pro bono than if you've done the case yourself, right? I was going to say this again and again. I could have done that more quickly myself. But a pro bono who gets engaged and gets involved can become a repeat pro bono, and that's when you start to experience the returns. And of course, it goes without saying, a pro bono who gets involved and who gets engaged is going to become a donor to your agency, and that really is a donor and a spokesperson for your agency. It's advertising. It is a way to show the community how you operate, what you are doing, and you may not be multiplying your force in terms of lawyers over the long haul, but you're definitely going to get the word out. You're definitely going to, the thing, and you're going to learn as well through that. So I might cut it a bit short. Just wrapping up saying we do the kids program in San Antonio. That again, quality and quantity are huge in that, and I think that brings the quality factor really first and really brings it home. I think when you're dealing with adults, you kind of feel comfortable just getting attorneys to them, and good luck. You're an adult. You got to make your decisions. You got to see if this person works with you or not, and best of luck. With the kids, obviously, the level of care, the level of concern is magnified exponentially compared to with the adults. You've got special considerations on how to represent a child. You've got capacity issues. You've got language issues with the children. A lot of them don't speak English, don't speak Spanish. They're from Spanish-speaking countries and don't even speak Spanish. They speak indigenous languages. So even if you've got the attorneys, getting them to communicate is an issue. In the right language and the right style and the right tone. They're not the corporate clients that they're used to. It is a difficult process. It's one we enjoy, and I want to follow up on it, but I don't want to take any more time away from Mr. Gonzalez. So I look forward to your questions. Thank you.
Okay, well, I have a couple too, but I'll hold them until the end. It's okay. I think we'll have plenty of time for questions, and it'll make the discussion a little better. So why don't we turn to David and hear from you about those issues that are at the intersection of criminal law and immigration law, and particularly the service delivery problems that you see.
Load up.
We're going to nice segment.
Ooh.
Okay. Cool. So arguably, we have what you want. We have access. Or we get you. You want civil Gideon. But maybe you don't. Okay? Because here's how our system works in terms of as bad as you got it. At least you got folks that are dedicated and want to help. Because I have this problem. Because when we talk a bit about the access models for indigent defense, I can tell you a lot and we'll go through some factors, but I'm not trying to get you to remember these things. I'm actually just trying to give you a few things that you won't forget. So the way we start in the timeline of an appointment is, at least in Travis County and in most major jurisdictions in Texas, you will get a fax, an email, a phone call that I need you to appear and represent somebody. And typically you'll get a name and an offense. DWI, robbery. And at that point, you then have some choices. At least for misdemeanors, you can choose, given the number of days between your appointment and court, whether you want to then locate them. We got a couple jails. You pray that you're downtown, which is close. That's Del Valley, which is about an hour away. If you then find them, because sometimes it's wrong, and you drive out there and they're not there, and they moved them and they didn't update the computers, okay? But when you do find them, you sometimes have to talk to them about something, because all you know is David Gonzalez and DWI. So I want to know about the case before I can engage in meaningful dialogue. So I need to go to the clerk's office and get a copy of this one-page affidavit. But they won't give it to you free, even though you're appointed, so you've got to have change to then make the copy. Now, once I've done that, if I want to get my client out on bond, or try to find their wife, their husband, anyone else, I will go to pretrial services and see if I can be able to get a bond form they filled out and start making some calls. But sometimes they don't interview them because they've got an INS hold or other holds related to that. Now, once that's done, I then make the decision to drive out there about 45 minutes. I then wait after checking in. Sometimes my client's ready, sometimes they're not. I will then meet with the person. So then representation, we're off and running. We're about an hour to two into it on this model. Okay. Then we have this cattle call. So if you were to take all these chairs down here, what jail call is in most large jurisdictions, it's really big on Thursdays here in Austin because it's in the weekend, you cram every single person, chair, all chained either together, okay? So this is your conversation with your client. There's someone to his left and his right, And so you can either stand in front of them and say,